seen headline-grabbing settlements that have been forced out of corporations, particularly in the US, arising out of the financial crisis. We've seen 10 billion, 12 billion, 15 billion levied against banks just to enable them to continue to operate as banks globally. There is a direct correlation between the powers of the investigators, the financial strength of the investigators, and the global reach of the investigators. The regulators are in a very, very strong position to become self-funding, and we can see with the DOJ the way in which they extract very substantial fines and settlements from corporations, particularly the banks, falling out of the 2008 financial crisis. And this perpetuates and strengthens the powers of the regulators. We also see that in the way in which the Serious Fraud Office in the UK received additional funding from the government because of the increasing ability that it has to reach settlements with corporations and for the monies to flow in to the government as a result of the investigations. What is not always seen is the impact on the individuals, not just the perpetrators, but also the directors who are responsible for the operation of the business. They may find that their corporation has reached a financial settlement and continues in business, but they are left with a criminal prosecution. There are many other jurisdictions where the ability to reach a financial settlement simply does not exist. And there, the regulators, the investigators, the potential prosecutors will see the matter through the courts. The consequence is that you can't reach a financial settlement, and one may be looking at a term of imprisonment. Companies have to assess the particular risks that they face in their business. For instance, the regions where they may be undertaking work and the way in which they procure contracts. They then have to establish a framework of adequate procedures to make sure that they do not fall foul of the regulators and that they comply with the law. In our experience, invariably there is a centre of gravity to an investigation. In practice, the wrongdoing often spreads across multiple jurisdictions where the law is different. For instance, the law of privilege is different from country to country. The way in which one deals with employees who may be subject to investigation varies from country to country. The way in which one deals with data or interrogates data also varies from country to country. And the result of that is that there has to be individual input, country by country, from lawyers experienced in dealing with investigations. There isn't a single approach that can be taken which is uniform and applies across all countries.